Hi, good afternoon. I'm Himanshu Srivastav. I'm a partner and director with ASA Corporate Catalyst India and ASA and Associates. It's my pleasure to be here with you. I'm going to be presenting about the new labor code impact on manufacturers. So this topic I have, since
Before, hi Himanshu. Before
yeah,
going further, I would like to give a brief instructions to the audience. Please allow me.
go ahead, please.
Uh, Thank you very much, ladies and gentlemen. I would like to welcome you to our webinar series on the Labor Codes 2020. So today is the first part of our two-part webinar series where we cover the implications and challenges of labor codes for manufacturers. Before moving ahead, I would like to give a brief about ASA and our speaker today. ASA is a three-decade-old accounting and consulting firm with a team of over 700 professionals spread across 8 offices in India. A major part of our focus is on foreign companies setting up and operating in India. Today, we are one of India's foremost accounting and consulting firms, assisting our clients in setting up their business, M&A, partner search, risk advisory, taxation, and compliance issues like accounting, payroll, IFRS, etc. Uh, as Himanshu has already introduced himself, I would like to give a brief introduction about him. He heads the business advisory services vertical at ESA. His responsibilities include end-to-end business strategy and project management services. He is an active speaker at national and international fora on topics ranging from doing business in India to exchange control regulations, corporate and industrial laws. Before we begin, here are a few instructions for the webinar. Please note that all the participants will be in listen-only mode throughout the webinar. If you have any questions or comments, please put them in the questions section in the chat box. The presentation will be followed by Q&A. A link with the recording to this webinar will be emailed to you tomorrow. Thank you, and over to you, Himanshu.
Thank you, Tarun. In my zeal to meet the timeline, I forgot. So thank you very much for covering up. It's an important that we actually give a little background to the audience. So thank you again. I hope you can hear and see me clearly. I am going to be just taking you through about these new labor codes and their likely impact on the manufacturer. Specifically, we have done a few sessions on overview of various, of the labor code, how it would impact the four labor code, which will actually be now notified. So how they're going to change the life of all the corporates. And this session is again follow through of that. We're going to be specifically covering how it's going to be impacting the manufacturers. So, I mean, this is just a background that we all know. Labor is an important topic, and the reason it is so important that because workforce is very crucial for any organizational success. In fact, it would not be wrong to say that an organization is as great as its people. So, be it a service company or a manufacturing company or a trading company or any kind of an entity, it's very important that the employment laws are paid due attention. Equally, when we say labor, it is much more wider term. Uh, of course, right now, since we are talking about the manufacturers, so we would not differentiate between the employees and workers and laborers, because we are just talking about the workforce. So there is no doubt that labor and workforce plays a very crucial part. And as we all know, there were multiple laws, as we have seen, over the past decades, that so much confusion really, was introduced by any new amendment by any state on any circular, be it social security, be it any health or family measure. So because of so much literature which was there for us to read and to implement, it was very complicated for all the corporates or employers and also employees to understand the actual impact. So the new labor code, as we understand, it really combines 29 specific employment and labor related laws into 4 codes. The summary is in front of you. Yeah. So basically, as we all know, that there are multiple laws which have been summarized into 4 labor codes: wage code, occupational safety and health and working condition code, industrial relation code, social security code. So yeah, so basically, these labor codes have been notified last year in October 2020, and the government has clearly stated that since the topic of labor is a concurrent subject, that is both the central government and state government can frame regulation. The code has been notified by the government, and the rules will be drafted by the state. The center has already given draft rules for the state to consider, and as I can update you that various state governments are now bringing out, and just the drafts are in the circulation mode, and maybe after due consultation with the stakeholders they will be implemented shortly. And it's very interesting to see that these labor laws and rules and regulation, which had been one of the talking point of foreign investors about how difficult it is to navigate them, they're going to be simplified and digitized because of these labor codes. Next slide, please. So this is a general slide, is that labor codes and draft rules, there would be an impact, and both it would require updation of HR systems, the government reportings, and probably we need to also look at our compliance modules. Next slide. Yeah, so when we really talk about the impact, we can assess the impact under 4 categories, which I understand is there's going to be a financial impact, there's an operational impact, a functional impact, and a regulatory impact. So it is very important at the outset, it is to understand that when we are really talking about the impact, it is going to influence the way we do business in India, and there are going to be multiple factors which probably have not been taken into account, and they would now be required to be studied and accordingly provided for. Next slide. So since we are really talking about impact on manufacturers, it is very important that we focus our attention on industrial relation, because this specific law, all the four laws are applicable to us, but if we emphasize this a little bit more, it could be a good starting point. Next slide. Next slide, please. Yeah, so we all know that the code on, just go a slide back. Yeah, so this code was basically to provide a framework, as we all know, for industrial harmony, rights and duties of employer and workers, and to, of course, further the objective of any industry as to have an ultimate pursuit of generating employment, generating economic value for the company and its stakeholders. Next. Yeah, so I'm just doing a bit of background because it is important to have any informed discussions. Is that whenever there is any discharge, dismissal, retrenchment, or otherwise termination of employment or denial of any dues to the worker, it can lead to a dispute, and therefore it is very important that all manufacturers should understand how and what are the provisions under the industrial code which will impact them. Whether or not there is a dispute, it's a separate matter, but even as we all say that silence is acceptance, even an omission could be treated as dispute. So it's important that we can go through the changes brought about by the code, and then accordingly prepare our respective organization. I'm very pleased to see a full house, and I can see a lot of fellow professionals and clients today, and I'm equally delighted to be able to update you based on my finding. Of course, there, due to paucity of time, we are just covering the highlights, but they are the changes as envisaged in the codes and the rules are very, very critical and requires due attention. Next slide, please. So amongst the first and foremost, I would say that this is the unique point of the code, and it's really important for all manufacturers having at least 100 workers, and also a separate category of 300 workers. So there are basically up to 100 and 100 to 300 and above 300. So law has really differentiated between these organizations, and primarily because MSME is one of the core uh, sector which the government is focusing. I would say that these laws are really sitting in full harmony while ensuring ease of doing business for MSME. And as we all know, MSME need not be just the Indian company; it can also be a subsidiary of a foreign company. And this formula, which the new definition really would accommodate a lot of these relaxation for MSMEs. So an industrial establishment in which 100 or more workers are employed has to have a works committee, and it it's quite possible that when we're sitting in April 2021, and maybe now the count of workers is 99 or less than 100. So in that case, this still is applicable, that they need to still focus on establishing a works committee. Then the other important committee is grievance redressal committee, and this, as we can all see, the threshold is 20 plus workers, uh, and it is very, very critical to resolve any kind of dispute within an organization. So I'm sure, except for the recently started manufacturing companies, I'm sure that 20 workers threshold is something that would really be impacting a majority of the corporates into manufacturing, including the MSMEs. So the grievance redressal committee, GRC, for the sake of my convenience, uh, can have maximum 10 members, which have to be equally 5 and 5 portion between employer and employee. And then if there are women in the workforce, then it has to be representative of the women workforce. Next slide. So for industrial establishment wherein 300 or more workers are employed, the central government has already circulated draft model standing orders. Now, what a model standing order is, that it's a very elaborate document which really talks about all the aspects of an employment. For example, classification of workers, how to record their attendance, various publications of working timing notices, how to transfer, retirement, how they can take leaves, what are the entitlement of leaves, how do you maintain record, how do you terminate employment, what are the medical facilities to be provided, and disciplinary actions for misconduct and termination of employment which can be done. So these model standing orders are applicable to organization which has 300 or more employees, and uh, state governments have been have been denied this the right which earlier they were uh, you know tinkering with the standing orders. So now the central government draft model standing orders, either they can be accepted as it is, or if the organization does want to have some customization or propose some modification, then in that case they have to prepare their own draft, and it will be called standing order, and have to get it approved by the authorities. So while the due date was within 6 months, and I can say that majority of the business community is still not very active, primarily because of the pandemic. But to my knowledge, if we really count from October, March was a deadline. I am sure and I'm expecting a relaxation in this compliance, because it's a very difficult time for the industry and for everyone. So standing orders, if there are customized, they have to be approved by a certifying officer. He would just see if the broad framework is duly complied with. Next slide. So a bit more on the grievance redressal committee. As we said, that it has to be comprised of maximum 10, and there has to be a decision making in the following formula, that at least 50% of the workers representative must agree to any decision. So I've given a formula which I'm sure is visible to to you all, and of course an example that in my view, if 5 and 5 is a equal representation by workers and employers, then I would assume that at least 3 employer and 3 employee representative must agree for any decision by the grievance redressal committee. Next slide, please. So if the worker is not satisfied with the decision of GRC, or if the decision is not taken within 30 days. So now here it is very important to see that now the statutorily there are 30 days timeline which have to be adhered to while GRC is functioning. So that equally exposes the GRC members of any violation of law if they're purposefully not taking it, and that's a discretion of, I would say, the adjudicating authorities, be it inspector or tribunal. So if the worker is not satisfied with the GRC, if no decision is taken, then he may within 60 days make an application directly to the conciliation officer, which is going to be appointed by state government through the and even through a trade union in which he's a member. So he, of course, he can himself approach the conciliation officer if there is no trade union, and beyond that, the worker can actually approach the tribunal if the conciliation officer has not taken a decision within 45 days of the application, and this application can actually be made up to a period of 2 years from the dispute. So it's a very open-ended time frame, and it exposes all the manufacturing companies and the management to such claims which assumingly might have been settled. So there has to be an adequate system of documenting every dispute, and documenting the settlement if any, or otherwise getting a solution in place or adequate preparation if the solution is not acceptable to either party. Next. So certain points we need to understand that all disputes can be subjected to arbitration, and during the arbitration the strikes and lockouts are not allowed. There is a prescribed format for arbitration agreement, and to initiate arbitration there must be a written agreement between both the parties, and then only the arbitration can be started. There has to be at this point of time, I would encourage all the corporates to also study the arbitration procedure which is given under the code, and how it is going to change. Let's say once a new code is implemented, in case there are existing dispute, so there can be several options with the tribunal or the national tribunal, is that they can be actually taken up from the same stage as they were pending at, or they can be started afresh. So all that effort which has already been devoted to resolve any dispute, or to to arrive at a particular, let's say, settlement, it might go waste. So it is need of the hour that all the relevant decision makers or responsible or authorized officials of the company should really take notice of these disputes and arbitration procedures. Next slide, please. So then I've already covered that. Please take these, I would say, pointers with you that evaluate issues while forming various committees in the organization, check the applicability risk, and of course, if possible, you can identify the troublemakers in the organization. I mean, nothing can be done about it, but then you can always prepare for the worst. Decide the members of these committees if possible, and of course, identify various applicable, let's say, conciliation officer, tribunal procedures, and take into confidence the key employees and representative of trade unions. Next slide, please. So a brief coverage of the trade union aspect in the code is that the trade union must be registered as a body corporate, and 7 or more uh, workers or employees can be signatories while forming the trade unions, and minimum 10% of the workforce should be or 100, whichever is lower, should be member of the trade union to be registered, and subsequent withdrawal of membership of trade union will not have any impact. Next slide, please. So again, a very niche aspect or a very specific issue under the industrial relation code uh, is that how do you arrive at decisions when it is subjected to trade union uh, acceptance. So earlier there was a lot of confusion because there were multiple trade unions with many small trade unions, and it was very difficult to arrive at a consensus. So the law provides a solution for it, is that a sole negotiating union has been proposed under the code, which will comprise of 51% of the workforce as member, and if this SNU, sole negotiating union, approves a decision, then it will be binding on all the workers. If there is no sole negotiating union, in that case, a negotiation council will be formed, which will comprise of various trade unions as members of this council. These trade unions must have at least 20% of the workers as members to be eligible to be invited to the negotiating council. So I've given some examples that if and it's you can see that if there are scenario 3 trade unions with 51, 31, 30 and 19 members, they will be a sole negotiating union because we have a 51% majority, and the acceptance by SNU will be binding on all. Scenario 2 will be there are 3 trade unions with 50, 30 and 20. In this case, as you can see that one worker can make so much difference to the entire decision making process. In this case, a negotiating council will be formed, and no civil court will have any jurisdiction over the matters before the tribunal. Next slide, please. So something about the strikes and lockout, very relevant in case of manufacturing companies, is that there are scenarios under which no person employed in an organization can go on strike. And what are these? It's already there that without giving 60 days or 14 days of notice, or within 14 days of the notice, during pendency of conciliation proceedings, or during pendency of proceeding between tribunal, 60 days thereafter. Similarly, these conditions are equally reciprocated in case of employers. Employers cannot also do lockout. Lockout means that just simply closing out the factory, and while the worker is keen to work, but the organization is not able to function. And of course, all notices received by employer shall be reported to the government within five days. So it's important that you have an adequate mechanism to document these communications, because it's going to be mandatorily required as a compliance and record keeping. Next. So retrenchment and closure, I would say very hot topic in any labor or employment discussion. However, the law, which is trying to do ease of doing business, and as we had already tasted, how an unregulated retrenchment or too strict a retrenchment condition can lead to I would say impediment or restrictions in growth of industry. So the government has really increased, gone beyond, increased the threshold from 100 to 300, and now uh, basically it is now possible for any organization which is less than 300 workers to retrench any worker or workers en masse. All the workers, let's say there are 200 workers. So in such case, the workers can be paid 1 month's notice of wages from 1 month, number one. Number two, compensation equal to 15 days average pay for each year. And number three, a notice is served to the government or other specified authorities about the retrenchment. And while, let's say, the next line which says that workers can be retrenched in last in first out basis, means that if some workers have been retrenched and within 1 year you want to fill up that position, it is, I would say, very I'm unable to describe it, but it looks very restrictive on the employer that you have to give the same employees who've been retrenched an opportunity to rejoin. So I would say that a bit of discussion is required in this aspect. And as I mentioned, no need to take any approval from the government. Next slide. So as a contrast, uh, from the earlier slide, this slide basically talks about 300 or more workers. So in such case, you need a prior permission from the government, and I've highlighted that. And as you can see, instead of 1 month, 3 month notice has to be given. And uh, the very, I would say, uh, shocking point to me in that the government is really trying to interfere in the commercial decision making aspect, as that the government can refuse the application within 60 days, and if the refusal is done, then there cannot be any further reference or an application to close or retrench workers for the next 1 year. So I would say that a lot of deliberation and a lot of preparation would be required. There would be no room for any mistake, and if luck favors, you will get permission to close down your organization. Of course, the reason I use the word luck is that there are other considerations, such as right now pandemic, and I would say other local factors, be it politics or otherwise. Next slide. So some specific issue, a reskilling fund has to be formed, and the employers must contribute 15 days wages drawn by the employee. So it would be an additional cost to the employer. So please take note, as should you actually retrench any person, you need to also contribute to this reskilling fund at the state level. And this fund is again going to be used to rehabilitate the workers. I mean, by paying, this will be paid to the workers who've been retrenched. And there are certain categories of workers who maybe are suspended for misconduct or some investigation. They have to be paid allowances as per this formula, 50% for a period of 90 days, and thereafter 75%. And of course, there are certain schedules under the code which are very, very important matters to be provided under the standing order. Schedule 1, what would be treated as unfair labor practices under Schedule 2, and third schedule will be is talking about condition for service for change of which notice is given. So these three schedules are topic by itself, and we can cover it in a subsequent session. Next slide, please. So very important, I would say, change in the labor code is a fixed term employment. That it says that worker can be hired on basis of a fixed term employment contract, and his hours of work or conditions of work cannot be less favorable than of a permanent worker. So there, the government is trying to control exploitation of contract workers, and this might, in majority of cases, as I know, would actually entail a lot of cost to the manufacturing company. They need to carefully understand this. And of course, the gratuity, which is now uh, would be a benefit to the fixed term employees if they any contract of work for a period of 1 year would be there will be a right on the worker to receive gratuity for against such employment. So all this, in my view, as I mentioned in my initial slide, that there's going to be a lot of financial operational function impact, and if there is any non-compliance, there's going to be a legal impact as well. Next slide, please. So other highlights of labor codes which I think will have a direct bearing on manufacturing companies are as follows. Is that first and foremost, changes in the wage code. So wage code has been formulated after combining these four important wage related legislations. Next slide. So the key change, I would say, the change in definition of wage. And I would say that at least, it's a much comfort to the consultant and or of course to the corporates and also to the employees to at least have one uniform wage definition in all the four codes. Earlier, there were so many different kind of wages being paid and the eligibility and the dispute associated that it was literally impossible to be saying anything with very uh, with confidence. But at least now you know what is comprised of wages. So wages comprise of basic pay, DNS allowance, and retaining allowance. So if the left side is less than the right side, what wages does not include, then you have to see what is the 50% of the average, and you have to deem that 50% to be the wage for the purpose of various calculation, as I've mentioned in the next slide. Yeah, just a simple formula for you to quickly grasp. Very simple figures. Looks very unrealistic because these are very low salary levels, but anyhow, so you can see that by our formula, wages would include basic DNS and retaining allowance. Retaining allowance means allowance paid to workers and employees to retain them. For example, in seasonal industry or when a manufacturing or any organization is not operational. I'm I'm not sure if this pandemic, which forces each of the organization to look at various probabilities. This can be one way of motivating and retaining employees. So you can see that under the Provident Fund, which earlier comprised of basic and DA, I would say the burden on the employer will increase. Similarly, in case of Gratuity Act, while you were calculating the gratuity, I'm sorry, it should be 15,000 each, not 12,000. I might have changed the figures last moment. So again, you please read Provident Fund and Gratuity Act as 15,000 each, not 12,000. So the burden on the employer would increase. However, in case of other compliances such as Minimum Wage Act, Payment of Wages Act, Maternity Benefit Act, ESI, I would say that the burden is decreasing. So as per the wage code, 15,000 would be the amount, and accordingly you really need to sit and evaluate for all your workforce how this simple change in the definition is going to impact the HR. Next slide. So the floor wages is going to be declared by the central government, and state governments have can also fix up uh, their minimum wages based on various categories: unskilled, semi-skilled, and skilled. And these minimum wages are applicable for all employees until the level of supervisors. So please have your, I'm sure they, given the fact that these are minimum wages, but just in case, ensure that you're fully compliant there. Payment of wages have to be at the end of the shift in case of daily weekly basis on the last working day, fortnightly within 2 days, and monthly before 7th. So before 7th of the succeeding month. So I'm sure that's also the tax withholding filing deadline. So it's fully complied, but just in case. So where an employee has been dismissed, he shall have to be paid within 2 working days. So technically, when before you dismiss or remove any or entrench any employee, you have to complete the homework before. But if he also resigns, you have to settle the dues within 2 working days. Very restrictive and impractical, but that's the regulation for now. Next, inspector cum facilitator. That's one aspect of the law which probably I didn't like, is that I I don't want frequent inspection to our client, or let's say to our organization. And given that this provision, which we used to read as students, there was a famous term called Inspector Raj, early 1990s. So now this appears to be returning. So there's going to be a bit of disturbance. I'm expecting that, given the powers of these inspectors, although the government has said that the inspector would try to do digital inspection, but at the same time he has the power to search and seize any property, examine any worker, or demand any information from the company. So all this, I'm sure, would lead to increase mind share and time share in catering to these requirements. I hope you should have an adequate system of labor law audit within the organization before uh, ICF comes knocking. Next slide. So payment of dues, another very important change in the wage code is that you cannot deduct more than 50% of total wages on account of fines or absence of duty or accommodation. So maybe in cases where employee has taken loan and he's absent from duties and he has certain fines, you still can't deduct more than 50%. So you either discuss it with the ICF and seek guidance, or you continue to pay 50%. And of course, one point which I noted was that you cannot even impose any fine without approval of the authority. In our case, inspector. So that's again very restrictive, and register of fines have to be maintained, and this collection of fine has to be used for certain approved purposes only. You cannot treat it as income and dividend to the shareholders. So again, quite a bit of restrictions there. And payment of claims, dues, and audit. So it's again certain within 3 years the is a time frame for the employees to raise the claim. So looks very I would say it's kind of a nuisance value, that within 3 years an employee can actually come back and say that I have certain dues to be recovered, and that will be taken at and considered. And failure to pay the amount can lead to recovery by the government. So you have to have now you cannot leave the labor regulations and matters just to the chance, since the law is giving you so much options to retrench workers and ease of doing it. Is again slowly ensuring that all the compliances are followed comprehensively. Next slide, please. So notice under the wage code means that you have to display on the notice board the summary of the wage code, so that people can understand various issues under the code. And you have to also train your HR. Category wise wage rate, wage period, and date and time of payment of wages have to be disclosed, and name and address of inspector cum facilitator. So I'm sure this is not too difficult, provided you already know who's the inspector having jurisdiction over your factories. So employer employing even 5 or more workers, for example, in agriculture, domestic, health, must also keep adequate, I would say, evidence of payment of salary. I just noticed it and brought to your attention. It might be worthwhile to consider. Next slide. Offenses and penalties, very strict. I would say any employer who fails to pay any employee or who pays to any employee less than the amount due, 50,000 fine for the first time. And if he repeats, and if he continues to fail, then it will be like within, he can have 100,000 rupees of fine and 3 months of prison or both. It doesn't look like a very investor friendly provision. Any provision contravention is first time 20,000, and again if it is a repeated offense or any other offense, 40,000 and 1 month imprisonment or both. And improper maintenance of record, that's where I want your all attention, is that it entails a fine of 10,000. It might look very small amount, but look at the last paragraph, that the inspector will only give you an opportunity to comply with the provision in case of first time offense. If you repeat the offense, then he has no obligation and he can decide without any opportunity being given to you, be it fine or imprisonment. I'm sure you would not want to report to your manager or director that he is going to go for prison because of a minor non-compliance. Would be a very uncomfortable situation for you to be in. Next slide. So then occupational safety, health and working condition, 13 laws were subsumed in this code. Next slide, please. I'll go a little faster here. That registration is mandatory within 60 days. In my view, these 60 days already lapsed in last November. But since the portal is not accepting, I'm sure there is going to be relaxation or maybe a late fee. The importance this registration number has is that it has to be quoted on all labor related document, including on the employment agreement. So you cannot miss it, or you cannot be excused of this compliances. And once you are registered, you have to file all the digital returns and all on a periodic basis. There are certain formats which are given under the code. What are the minimum contents of letter of appointment? I'm sure we all have much more comprehensive. I've seen this format, but I would say that do take notice of this. Any accident has to be notified to the authorities. Any disease such as COVID now has to be notified. Registers have to be maintained, including of accidents. You have to file an annual return also, and you have to maintain a register for leaves with wages. I'm sure these are already been complied with, but I think there is a need to revisit the records and maybe take notice of the new formats which are there in the code. Next slide. This is another notice board, but under this code is that this notice board technically should have almost all the issues that were mentioned in the last notice board and the wage code, but it also has to have details of accidents and any dangerous occurrence in last 5 years. So I'm sure you're going to need a very large notice board to display all these kind of information. So that's an homework for the General Affairs Department. So be ready with it, and this notice has to be in Hindi, English, and local language. Next slide. Contract labor. So when these labor code came, there was a lot of discussion that now contract labor is going to be prohibited. What is going to happen? So every establishment in which 50 or more contract labor are employed or were employed in last 12 months, it is covered under the code, and every manpower supply contractor is also covered. So to my knowledge, many of our clients, for example, American or Japanese companies in engineering, procurement, EPC service, or trading companies for that matter, would also be covered if they are into EPC business. Contract license mandatory for contractor, and it is prohibited to employ contract laborers in core activity. I'm going to be covering this in subsequent slide. There are 3 exceptions to the rule, which I'm sure by now you have read, how and under what circumstances you can have contract labor in as an except under the exceptions. Next slide. Core activity. So core activity means any activity for which the organization is established. For example, our organization, which is an accounting and consulting practice, that's our core activity. And what is not our core activity is, various categories which are there. I was just giving an example, but for manufacturing companies, it will have a bearing that they cannot have contract labor except through registered contractors. So these contractors, to be able to supply contract labor to the company, must be audited to ensure that they are providing all the statutory benefit to their employees. Next slide. So health, safety, and welfare conditions. This is, I'm sure, already complied in most of the corporates, but if there is any gap, please do take notice of various issues mentioned therein, like I'm sure drinking water and cleanliness hygiene is adequately ensured, but maybe now, let's say, washing and bathing room for transgender, the third gender, is something which is new. Locker rooms and drying rooms, and some facility, I mean, canteens are more or less universal. Crèche facility is again a very important factor for all the organizations now. And I was just reading the rules of Haryana state. These are going to be very strictly implemented, and there are specific guidelines under, let's say, for example, Haryana rules, how big these facilities should be, and how much social distancing, I mean, how much size a child should be provided, uh, for these kind of nursing cares. So, and how many times of mothers can visit these crèche facility under the maternity benefit provision. Next slide. So please study about these conditions very carefully. So basic work rules: maximum work 8 hours a day and 6 days a week, and overtime of 2 times the rate, and maximum overtime can be 120 hours in 1 quarter in 3 months. Annual leaves with wages, of course, they can be, if worker is discharged or dismissed, you have to pay his wages in lieu of leaves within 1 day after such event. Again, before you decide to terminate anyone, do your homework and meet this deadline. If the worker is retired or dies while in service, surprisingly, the government is very considerate by saying that you can pay his dues for within 2 months. I would say it is better to resign rather than retired. So for maternity leaves, layoffs, and annual leaves should be counted as work. So, and any holidays falling between the leaves will be excluded. Not sure if people are doing it, so please pay attention to this fact, that any holidays falling between maternity leave would not be part of maternity leave. Leave encashment can be carried forward for 30 days. If you are denying the worker, then it can be unlimited. So please don't deny if the worker asks for any leaves. Specifically, since then he is entitled to, there's no limit, and maybe next year, if it's possible that the lease may lapse, but it's a good provision in favor of employees who can accordingly negotiate with their organization. Next slide, please. Hazardous processes. So whatever dangerous activities or any processes which has a threat to the life or well-being, should be documented. there has to be every occupier of the factory, means either the manager or director of the factory must maintain health record of workers who are handling chemical or toxic or hazardous substances, and they need to appoint a person with right qualification and experience in handling the hazardous substances, and this can be on contract basis. Also, medical examination is now statutorily mandated, and I've seen the format. It's quite comprehensive. So do familiarize yourself with the medical examination format. Next slide. Confidentiality, major issue for all the organization is that although everything, all, let's say, all copies, records, registers acquired by the ICF inspector are treated as confidential, but in case the inspector feel that this disclosure is necessary for the health and welfare of the workers, he can disclose it. So again, it's not going to be very easily digested by the employer that all that sensitive information which they were trying to ensure the protection of can now be compromised. So you need to reassess, do a bit of your data protection, check the protocols, and again be ready for the labor codes as and when they are fully operational. Next slide. So again, certain pointers on code and social security, which subsumes 9 labor codes, are as follows. Next. So key features that it covers: social security organization, provident fund, covers maternity benefit, and certain new category of employees and workers like gig and platform, and some employment exchange. Next slide. So these are the threshold for employees to be covered under provident fund, pension scheme, deposit link: 20 or more employees. Under ESI, it is 10 or more employees in hazardous work. Gratuity, 10 or more employees. Next. It can be voluntarily. You are free to cover yourself voluntarily as well. Next slide. So types of workers. Happy to see that the regulations are incorporating new age concept into the regulations: home-based workers and self-employed workers. Next slide. Gratuity. So again, as we all know, it's due on completion of 5 years of continuous service. And continuous service, there are 3 exceptions wherein death, disablement, or expiry of fixed term employment. 5 years is not mandatory. So gratuity is payable every completed years into 15 days for every, let's say, month of 26 into last drawn wages, and wages as per the calculation we just did in a few slides back. 15,000 was the amount in the example. So some impact is that you need to assess how it is going to increase. Also on contract workers, now you need to pay wages, fixed term contract employment. Case of employees retrenchment with sole intention of avoiding gratuity, I'm sure it's going to get the strategy is going to be impacted. You need to reassess, and you have to pay the gratuity through a demand draft or by RTGS. Not the check is not going to be working anymore. Again, a very pro-employee decision. Next slide. So maternity benefit, I have just highlighted. We all know, what are the benefit: 26 weeks of paid leaves. But additionally, there is a concept of this medical bonus of 3,500, where the organization does not have any prenatal confinement or care. So this would be an additional cost. So employee with 50 or more women employees shall provide a crèche facility. So this I've already spoken, but this is specifically under the code. And this limit has to be seen on company basis. and not on branch or department wise. So if a company has 2 factories in India, you have to see the employees in total. Next. So career center, any vacancy has to be notified to these career centers whenever they are. Of course, we have employment exchanges in some states. So it's an important tool, I would say, to help people, an organization to match right skill with right candidate. Next slide. So certain formats which I just thought I'll just mention to you is that there are defined formats so that there is a uniformity. Even for gratuity, you have to claim in a specified format, and if you want to reject it, then it has to be in a specified format and has to be reasoned. Next slide. In case of maternity benefit, it is now mandatory to give certificate of proof of pregnancy and delivery and miscarriage, and also uh, any benefit denied can be complained against the employer in a specified format. Next slide. So as a summary of changes, and despite I'm slightly overshooting, please bear with me. Despite all that we went through in the initial, this is the crux of the impact on the manufacturers, that educate all your stakeholders now, the management, employees, all divisional head and important decision makers, be it HR, accounting, or legal section, about the compliances, risk, and impact. You really need a comprehensive assessment of the regulations. uh, Certain, as I mentioned in the beginning, there are certain functional impact and operational impact, as simple as you know having a specified format for the appointment letter, and also certain mandatory contents to be put up on the notices, what all digital compliances you need to do. So probably some formats have to be fed into the ERP, and then you should be able to take out the digital reports and file it accordingly. Registers, new registers have been mandated. Standing orders, if you remember, we stressed upon it, is one of the most regulations, apart from other regulations and other laws and condition which are going to impact. And it is now a requirement, point number 2, to overhaul the HR and factory management manual completely. With the new safety standards and processes, I have just given you an overview of these because detail was not possible, because it can be a separate discussion altogether. Maybe now the employers need to enhance their employment budget. As we calculated, somewhere the impact is going to increase and somewhere it's decreasing. So would it have any impact on the employment or employment agreements, or just assess that on the profitability of the organization? And also point number 4, how all, while you as an employer and organization are doing all this to containing the impact, how it is going to impact the employees. Because as I mentioned, employee are the backbone of any organization, so it is equally important that you do an adequate and a very transparent discussion with the employees and give them the right picture of any change that you're going to bring about in your organization. A transparent discussion would, I'm sure, entail full cooperation and would lead to lesser number of dispute, which we have just noted how severe it will be to come out of any dispute. So avoid having one. Point number 5 is management policies, of course, need a relook. You have to really assess the risk. Maybe you need to change certain signatories and certain, let's say, if you have a director as an occupier, maybe you now need to delegate it to a more senior, uh, but say maybe a senior manager, and change the reporting pattern. And maybe you need certain changes in, let's say, your internal softwares and tools which you have already. taking into consideration what has been mandated. Last and very important is dispute resolution mechanism. It's fair to both employer and employees, but then it can entail huge cost. Do study that. Next slide, please. So with this, there are other considerations. Are you ready with the impact analysis? If the majority answer is no, then it is time that you discuss with the right person, and one could be us. If you think that we have given you a flavor of the changes, of course, for industrial establishments with 300 and more workers, this is going to be a massive exercise, and you have to have right strategy. Many questions I have, for example, studying the roles and powers of inspector cum facilitator. How exposed are your CEOs and MDs because of non-compliances under the code? How do you hire contractual laborers, and how it is going to impact your HR plans? Is your contractor compliant? So you need labor law audit as well. And of course, ultimately, the stakeholders or shareholders are going to be interested and keen to know how is it going to be impacting the profitability. Salary is just one example, but the cost of meeting the compliance would again entails, I would say some budget. In my view, huge budget, because the changes are not just cosmetic. And of course, the confidentiality of the corporate information is very, very crucial. Please do take care of this and prepare accordingly. We will be very happy to guide you if there are any queries and questions. Next slide. Thank you very much.
Thank you very
So
much, Himanshu.
yes,
We
thank you
have
very much.
received some queries. So due to paucity of time, maybe we can take a couple of queries. First one is whether the compensation of 15 days will be in addition to gratuity or not.
Yes, in addition to gratuity.
Thank you. Second query is retrenchment clause is not applicable to employees.
Not applicable to?
Employees?
It is applicable. It's both ways. Retrenchment can only be done by employer. Employee can simply resign. Of course, they have remedies, as I mentioned in the slides. What remedies, what rights they have. Employees cannot retrench themselves.
Okay, sure. Thank you so much, Himanshu, for sharing the insights through this session. So I would like to take this opportunity to thank our audience for joining us today. Our session on Thursday next week will discuss the implications of labor codes on the services sector. Link to the recording will be sent to the audience, entire audience tomorrow. As there were some questions which we could not take up due to paucity of time, we will reply to each query individually over email. If anyone has any further questions, please do not hesitate to contact us. Thanks a lot. Thanks a lot, Himanshu. Thanks a lot, everyone.
Thank you all for your patience. Thank you, my team, Kim and Tarun.
You're welcome.